Hi, good afternoon. My name is Rosemarie Ferrante. I'm an attorney in Connecticut, and my practice focuses solely on non-adversarial divorce processes, which are mediation and collaborative divorce. Today, our program is focused on certified divorce financial analysts and their roles in the non-adversarial divorce process. I'm going to be introducing my colleagues in a moment, but I just want to share that this event is part of a week-long series of events that CCND is presenting. The Connecticut Council for Non-Adversarial Divorce is a statewide nonprofit professional organization. Our membership includes professionals from the legal, financial, and mental health industries. And our mission is to change the way people divorce in Connecticut. Today, I am joined by my colleagues, Mark Soboslai. Mark is a collaborative attorney and mediator with a practice in Fairfield, Connecticut. Mark practices, all non-adversarial or out-of-court processes, such as collaborative divorce and mediation, which again we'll talk about. Mark began his career as a family relations counselor in the New Haven Superior Court, and he's created a dispute resolution course for law students, which he's taught every year since 1989. Hi, Mark. Nice to see you.
Hi, Rosemarie. Nice to see you.
We're also joined today by Traci Provost. She's a certified divorce financial analyst with an office in Westport, Connecticut. Traci is trained as a collaborative financial neutral, and her focus is financial planning, evaluating divorce settlement options, and acting as a financial therapist to help people move forward in a positive and productive way. Hi, Traci.
Hi, Rosemarie. Hi, Mark.
And I'd also like to introduce Hollis Hardiman. She's also a certified divorce financial analyst with offices in Wilton, Connecticut. Hollis is trained in mediation and the collaborative divorce processes as well. And she specializes in helping clients navigate periods of transition such as divorce, widowhood, and retirement. Hi, Hollis.
Hi, everybody.
Hi.
So as I'd mentioned, this week is Divorce with Respect Week, presented by CCND. And we've been so fortunate to have over 55 of our members volunteer their time to provide free consultations to people explaining non-adversarial divorce in Connecticut. And we've also had many of our members participate in events such as this. We've had 10 events scheduled this week with our professionals, again, providing the public with information and resources on non-adversarial divorce. So thank you, guys, for joining me today. We're going to start with Mark. And Mark, if you wouldn't mind, just a brief explanation of what divorce mediation is.
So the first thing I would say about divorce mediation is that, as you said before, Rosemarie, in your introduction, it is non-adversarial. And typically, both spouses will meet with either one mediator or a co-mediation team. It could be a lawyer and a mental health professional, a couple of lawyers, lawyer and a financial professional. And the focus is upon helping the clients themselves, the spouses, to work out their own resolution to the case. And the focus of a non-adversarial proceeding is so that you don't have to go persuade a judge to do something, but you can actually help the two parties themselves. So divorce mediation is very much focused on that goal.
Thank you. And so we'll talk about the similarities in a moment, but can you do that same sort of brief explanation on what a collaborative divorce process looks like?
Sure. Collaborative is a little bit different. First, it is based on the same principle of self-determination, and it is also non-adversarial. The primary difference is that when we begin a collaborative case, each of the clients, each of the spouses, has their own collaborative attorney. And we sign an agreement at the very beginning that we're not going to court, and that we will not be arguing as if we were going to court. We also often bring in a financial professional, such as Traci and Hollis, and sometimes even a mental health professional to help, often in cases where there are children involved, to help with the parenting arrangements.
Thank you. So it sounds like both of these processes, again, are non-adversarial. The court is not involved, and the team looks a little bit different. So in a mediation, both spouses are working with one mediator who may be an attorney, but is not acting as an attorney for either party. In that situation, Mark, do the clients have the opportunity to meet with their own attorneys?
Yes, absolutely. Most capable mediators are going to suggest that before anybody signs anything, any agreements or whatever, that each should take a draft agreement or a memorandum of understanding stating the ideas for settlement to their own separate attorneys. We often call them consulting lawyers or review counsel. And many of those lawyers are sensitive to the fact that these individuals have participated in a non-adversarial process, so they often cooperate in ways that help the process along.
Yeah, good point. And it really is the role of a review counsel is to support the process and to help clients understand their options. Because I tell people oftentimes mediation gets messy before it gets clean. And we're breaking down a lot of discussions. And sometimes it's really helpful, usually it's really helpful for people to be able to meet with their own attorney and just get a better understanding of those conversations. Um, Thank you for that. The other part I wanted to ask you about, if you don't mind, on the collaborative that you mentioned, is this participation agreement. So, in the collaborative team, again, rather than there being one mediator, the spouses in every meeting have their collaborative attorneys with them, and then potentially a financial professional and a mental health professional. The participation agreement that you refer to, that everyone signs so nobody's going to court, is an important part of the collaborative process. Can you just touch a little bit more on why that's so important?
Yeah, the participation agreement actually embodies a number of promises that we all make to each other. That, for example, the lawyers are promising that we are not going to use the threats of litigation. We're not going to use the typical tactics that you might find in an adversarial process where lawyers are arguing in ways that sometimes take the case in a direction that it shouldn't go. The lawyers are trained collaboratively. So we sign that participation agreement as a way of really cementing our commitment to the fact that we are not going to court and that we will abide by the principles of collaborative practice, which are well established through the American International Association of Collaborative Professionals that we follow.
Thank you. And that training is so important because, particularly, I think we've seen in Connecticut and elsewhere in the country with COVID and closures of courts and backlogs, people are looking for alternative ways. And so, for anybody who's interested in learning more about mediation and collaborative law, please go to CCND's website. It's gooddivorcect.com. All of our professionals are trained in these non adversarial processes. So I'm going to switch now and talk to our financial professionals for a moment. Traci, can you please tell us, what is a CDFA? What does that stand for? I do think that there's some confusion in the public with the various acronyms assigned different financial professionals. So if you can give us a breakdown of that, that would be appreciated.
Yes, of course. A CDFA is a Certified Divorce Financial Analyst. It is a very narrowly focused certification that we are trained for, that we have continuing education for. I also believe, and maybe I'm a little biased, that I think it is one of the best resources for people going through divorce in any capacity. The assistance of a certified financial divorce analyst like Hollis and myself. And it's interesting, Hollis and I worked together many years ago, and we both found this track of working with people going through a untangling of their marriage, helping with their finances, because that's one of the areas that many people are so scared of, and it keeps them held up in the process. So we can talk about that a little bit further, but that's what a certified financial analyst does. It works with clients to help them understand what they have and what their potential future could look like in the near future and in the far future.
Thank you. And I meet with both potential clients together. And in talking to them, I always talk about the three prongs of every divorce. And I think we've all probably had these discussions. The legal is only one piece of it. The financial is another, and the mental health is certainly another. And the more prep work I find that people do on the emotional side and on the financial side makes the legal side so much smoother. And so the assistance of CDFAs and, of course, our colleagues in the mental health profession certainly help Mark and I do our jobs well. So, Hollis, when you're working in a mediation, can you give us an idea of what your role might look like?
Sure. So a lot of my role is gathering information. It's helping both of the people involved understanding what their assets look like. That includes their income, if there's restricted stock, if there's stock options, their assets or their pensions, IRAs, 401ks, and then understanding their expenses and really making sure that everybody is on the same page as far as what's coming in and what's going out. And once we have all that information, it just puts everyone on the same playing field so that if one spouse prior may not have been that interested or maybe privy to information, they now have all the facts to make an educated decision as they move through the process. And like Traci said, I think a lot of people get stuck in the finance and they're so worried about, not having it treated fairly that they automatically resort to litigation thinking that's the only way they're going to be represented fairly. And I think when you have a CDFA part of the non-adversarial process, everybody feels a little bit more comfortable that there's an even playing field.
That's a really good point because every family is so unique. And so every family's divorce is very unique. And the team needed to support that family through the divorce is specific to their needs. And so in some instances, again, we may have our colleagues come in on an emotional side, help with parenting plans, co-parenting situations. But when it comes to finances, people can certainly get stuck in that. And so one of the roles that I've seen CDFAs assist in is helping one spouse who hasn't had the opportunity, or frankly, just in terms of their family dynamic, wasn't involved in the finances, so may not understand it. And often they're going from a place of fear and they feel they need some protection. And I think that's what you're talking about, Hollis, with hiring a litigator. So Traci, can you speak to that a little bit? Because I know that many of our colleagues have called you a financial therapist. And so in situations where you are a neutral, but your goal is to help one spouse even out that playing field that Hollis referred to, how do you go about doing that in a collaborative divorce setting?
So Hollis is 100% right in everything she said. The same is very true for collaborative as well. The financial neutral role in collaborative divorce is a single source is gathering all of the financial data. What that means is that one attorney is not gathering it for their client and the other attorney is gathering it for his client. It's one resource for the entire process for the family to see what they have. And I kind of break it down into 4 quadrants. They need to know what they own, what they owe, what they earn, and what they spend. So I try and break it down into a very basic, dialogue for the client. But it's always really important that a CDFA understands their clients and understands the financial education level they are at. So that's where I always start with a client, is figuring out, and most times they're not exactly on the same page financially, but to figure out where the clients are, to meet them at that point, and then kind of customize the way in which I communicate about finances to them in order to accomplish the fact finding and the asset information that's needed in order to help them divide the assets and begin to live a separate financial life.
Thank you. And so that really, what we've been focusing on so far is the fact finding and the gathering of information. So Mark, from an attorney's perspective, the fact that you have one financial neutral, again, whether it's in a mediation or a collab, gathering that information, how is that different than an adversarial process? So that people who are contemplating litigation versus a non-adversarial process understand what both look like.
So one of the things that is particularly troublesome for people in the adversarial process is this process that we call discovery. And typically when each spouse has a separate lawyer, that lawyer is going to engage in extensive discovery to get information related to the financial picture in the case, right? So each spouse is paying a separate lawyer to gather information that in the process that Traci just described and Hollis described, the role of that financial neutral is actually, in many ways, taking the place of those two lawyers duplicating efforts to get information. It doesn't mean that lawyers cannot ask for and get information. In fact, the collaborative process is based upon full transparency. But when you delegate that role to that particular financial professional, the clients invariably save money. And secondly, that financial professional comes in with basically a neutral perspective. It's not like they are anchored in, advocating for one side or the other. And that means the negotiations can actually start on a more neutral playing field, essentially, as both of the financial professionals mentioned, to educate the parties together. And that's a very, very significant difference in terms of the starting point compared to when people have separate lawyers, separately gathering and evaluating the case, and then separately coming into the negotiations with their positions that they've staked out without necessarily even really thinking about the potential for those positions to move the negotiation in a negative direction. So having those financial professionals is critically important to keeping everybody on an even playing field and really keeping some degree of neutrality in the process.
Thank you. Oh gosh, there's so much to break down in what you just shared. So thank you. But I think where I want to continue the conversation a little bit and bring Hollis and Traci back into it is we often hear from clients, they think maybe their spouse is hiding money, dissipating funds. How will we know? What if I don't have a lawyer do those, depositions or subpoenas? So if either Hollis or Traci can speak to that a bit, are there instances where you both will involve other financial professionals, be it appraisers, CPAs, business valuation experts, and how does that look in a collaborative or a mediation?
So I was just thinking, and although you were kind of talking about hidden assets a little bit, just to kind of turn a little bit away from that, what I like about the non-adversarial process is that we're also thinking forward past just the the immediate asset division and the lawyer's done and then you move on. And so, for example, a lot of times it's required for one of the spouses to refinance. And it's really important to understand what comes with refinancing. So, for example, I had a client today. We had reached out to a mortgage broker, and in order for her to refinance, she needs to show that she's making $20,000 a month. And if we didn't have that information, we may not be able to expedite exactly what the divorce decree was potentially intended to do down the line. So now we can bring in the husband and say, if you want her to refinance in her own name, these are the different steps that need to be taken, whether we can show it now or later, however it gets done. But we need information to make sure that the decree itself can come to life. So I find mortgage brokers really helpful in that scenario.
Thank you. And you kind of, jumped ahead because your brain works much faster than mine. But, I think that when we're talking about the gathering of the documents and then where you are really is then you're analyzing them and identifying the issues. And that's such a big part of what you both are doing. So when we're still talking a little bit about the fact finding, Traci, what do you think, just in terms of, again, values? Who else might we be bringing in to just gather the right information so both spouses have the financial information, so then you and Hollis and the financial teams can help them identify the financial issues, and then we can move forward in our discussions and negotiations, right?
Right, exactly. Well, I think for a lot of clients, a CPA is a very important component. As CDFAs, we're really not allowed to give tax advice. We are not CPAs. It's not what we do. So I count on many CPAs for help, not only in very complicated financial situations where there's a lot of tax implication, but also to help perhaps the client post-divorce manage. It's a little less important now because alimony is no longer a taxable event. But prior to 2019, where a spouse who perhaps never was an earning spouse and is paying taxes on the alimony, and that became a big issue for them after post-divorce. I do find a lot when a client is leery of there being hidden assets, and how can we be sure? How can we be guaranteed? And obviously there's no guarantees in life, but forensic accountants are important. I will say that I don't recommend those kinds of specialists like a forensic accountant unless there is serious doubt and an idea that there are in fact hidden assets, because it can prove to be a very expensive expert witness, and it may not always prove the results that are needed. So CPA is usually my go-to. I agree with Hollis as far as a mortgage broker, because I would say in more times than not, one of the spouses is going to keep the house and going to need to refinance. And so how do they do that if they didn't have the income? And there are a lot of really excellent mortgage brokers out there that deals especially with people going through divorce.
Thank you. Yeah, and you both brought it up, and so let's break that down a little bit, because it is such an important part of most of our divorces. Many times there's an emotional attachment to the house, and so we as divorce professionals on the legal side may have to speak to clients about what is your goal. We're not talking about positions. Mark had touched on that before. In litigation, your attorneys are advocating for you based on positions. In mediation and in collaborative divorce, your divorce professionals are trying to help you identify your goals. And so if someone's goal is to stay in the house, then of course we have to explore, is that financially feasible? So Mark, I'm going to kind of bounce that back to you. In your experience, is bringing in the refinance discussion early in the process the best way to have that discussion?
It's such a wonderful question. One of the things that we do as the professional team is we evaluate those exact types of questions together. Before we set foot in that room, we will have a meeting beforehand to try to create the agenda. And if there's a really hot button issue, the true spirit of collaboration is for us to really be aware in advance that something is going to be a potentially emotional issue, a potentially explosive issue, whatever it may be. And we separately get that from our clients, but we collectively try to manage the process. In fact, a lot of people will use the term, we create a safe container within which those kinds of things can be discussed. So if there really is a strong emotional connection to anything, whether it's the house or it's something else or it's something involving children, this process is the absolute best way for people to engage in those difficult discussions, because we don't add fuel to the fire. We try to really contain those discussions. And one of the main ways we do that is to plan in advance. So I don't necessarily think that we would bring in the refinance discussion early on. I think what we would do is together make the determination as a professional group with the clients, when is the best time for us to talk about that issue in the context of a collaborative process.
Thank you.
Rosemarie, can I add to that?
Please.
So I think one thing Hollis and I would agree with is we probably both do financial planning for our cases, right? If somebody's going through the adversarial process, they're just talking about a split of assets. Nobody's telling them what that division of assets is going to mean for them, for the financial, now and for the financial future. And so when a question like that arises, or when an interest like that arises of one person wanting to stay in the house, a big part of a CDFA's role is to help them see what that looks like from a cash flow perspective. Well, if you want to keep the house, here's X, Y, and Z of what that looks like for you. And that's a hugely important tool for clients. It should happen more in the adversarial process, because I get cases after they've gone through the adversarial process and they didn't really understand the financial division of assets, nor what it was going to look like for them financially in the future.
That's such an important point. And that's what we're trying to avoid, because their final divorce agreement is the blueprint for how you're going to live your post-divorce financial life and parenting life, assuming you have minor children. If people don't understand that blueprint, where are they in the future? They need to understand that agreement inside and out, and then understand how to effectuate it. Because I'm sure both of you as financial professionals have seen people 2 years later who haven't had their retirement assets divided or didn't know RSUs were vesting. And we can have a whole nother discussion on those issues, right? But what I want to get back to, Traci, is one of the things that you'd mentioned early on is you ask people to identify what they own, what they owe, what they earn, and what they spend. And in other words, that's their financial affidavit. A financial affidavit in every divorce in Connecticut needs to be filed, whether it's in a collaborative setting or in a mediation setting. And it's a sworn affidavit setting forth your income, expenses, assets, and liabilities. So, Hollis, can you talk a little bit about how you help clients with preparing that? Because I know that is one of the hardest things for most clients to do.
Yeah, I mean, this is probably where a lot of people get stuck. And it's one of the harder points of getting all the information. What I do is I really encourage clients to use, either a software that they can hook up to that they have with their credit card, or a software that I use that helps them categorize their expenses, because going through credit cards and looking through past months of expenses there's no reason to spend that time when there's softwares that can actually do it for you. So I think it's really important to make sure that you're up to date with the latest, financial apps that you're comfortable with, so that you can expedite that process and not be so overwhelmed with figuring out your expenses.
Thank you. Oh my gosh, I cannot believe we have only 1 minute. That went super fast. We're going to have to do a part 2, but thank you. So again, the discussion today was about how certified divorce financial analysts like Hollis and Traci can assist in collaborative and mediation non-adversarial divorce processes. Thank you, Mark, Traci, and Hollis, for being here. This was a great discussion. And again, I feel like we should absolutely have a part 2.
Thank you,
for
Rosemarie.
having us.
Thank you.